Welcome back to the Deep Dive. We're here again, taking these really complex topics and trying to distill them down into the key insights. Today, we're actually jumping into part 6 of our ongoing deep dive into the Jeffrey Epstein case. And for this part, we're really going to focus on the women, the incredible courage, really, of the women who just refused to be silenced. You've sent us, a stack of sources, verified testimonies, court filings, official reports, the works. And our goal here is to, shed light on how their voices fighting against just immense odds eventually led to public accountability for Epstein and Ghislaine Maxwell, too.
It's really compelling when you start tracing the specific legal paths these women took. I mean, we're going to look right at their legal fights, the civil suits they brought, and importantly, those pivotal settlements that really did change the whole trajectory of this case. It's honestly a powerful look at what individuals and then groups can achieve.
Yeah, individual and collective action.
Okay.
So let's start with the official alarms sort of first went off. The sources point pretty clearly to 2005.
Right. That's right. It starts when the parents of a 14-year-old girl contact the Palm Beach police. They reported that Epstein had paid their daughter for a massage.
And that single report, kicked off an investigation.
It did. And the police, well, they pretty quickly uncovered a pattern. It wasn't just one incident. They found Epstein was using personal assistants to recruit young girls, specifically for massages. And these massages often led to sexual activity.
Okay, so the police see a pattern, they investigate. They get an arrest warrant.
They do. They obtained an arrest warrant. But then something pretty unusual happened, especially for a sexual violence case. The Palm Beach County State Attorney, Barry Krischer, instead of just filing the charges based on the warrant, he took this, well, unprecedented step. He referred the whole thing to a grand jury.
Wow. Okay, and that's significant because
the evidence seemed to point towards really serious charges. Things like lewd and lascivious molestation, unlawful sexual activity with a minor, serious felonies. But Krischer's office, when they went to the grand jury, they only presented evidence relating to one victim, and they only sought one count, a much less serious charge of prostitution.
So a major downplaying of the evidence the police had gathered. That seems like a huge moment of, well, resistance to holding him truly accountable right from the start.
Absolutely. And the police themselves, the Palm Beach chief and the lead detective, they weren't happy about it. They saw what was happening. Because they were so dissatisfied with how the state was handling it, they actually took the case to the FBI. They referred it for a federal investigation. And that federal investigation started up in September 2006. Its specific focus: child prostitution.
So the feds are now involved. Let's talk about how these girls were even brought into Epstein's orbit. The sources detail these recruitment methods, right? They seem quite manipulative.
Incredibly so. We see examples where a designated recruiter would approach young women, like one named Mrs. Arios in the files, and they'd paint Epstein as this, caring, very wealthy, very successful figure, someone good to know.
The implication being he could help them with careers.
Exactly, that he could guide her, help her with acting or modeling aspirations. It was a lure, basically.
And there are police reports backing this up directly.
Yes, there's a specific Palm Beach police incident report in November 2005. It details an interview with a 17-year-old. And she talks about Epstein's power, specifically linked to his money. She described this routine, foot rubs, calf rubs, that then escalated to him touching her vagina.
Wow.
And she also mentioned that Epstein and his assistant, a woman named Sarah, would call her directly at her father's house to arrange when she would work.
Chilling. And the sources show this wasn't just a one-off. This was the method.
It was a clear pattern. Jane Doe number 2, for instance, she was 16 around 2004, 2005. She described the same thing. Recruited for massage, it led to sexual intercourse, and she was paid $200 afterward. These early accounts, they just paint a very stark, undeniable picture.
Okay, so we had the initial investigation, the state's controversial handling, the FBI stepping in, and this clear pattern of recruitment and abuse. Now we move into 2007, 2008, and the legal maneuvering really ramps up, right? Epstein's team pushes back hard.
They do. Immediately, his defense lawyers started lobbying for something called pretrial diversion.
Which is basically trying to avoid prosecution altogether.
Pretty much. It's usually for less serious crimes. You meet some conditions, the charges can be dropped. It was highly unusual to even seek that for charges like these. It's sure they wanted to minimize any real consequence.
And this is where the victim's rights aspect becomes really problematic. The prosecutors knew they were supposed to consult the victims.
Internally, yes. The federal prosecutor, Marie Villafana, she noted internally that victim consultation was, and I quote, required under the law. But
Epstein's defense had a major sticking point: the sex offender registration. They fought hard against that, calling it a life sentence. They even claims there'd been a miscommunication about whether the state charges would require registration.
So they're negotiating, pushing back,
Yeah.
and eventually they reach a deal, the infamous NPA.
Exactly. The non-prosecution agreement, an NPA.
Yeah.
And just to clarify for listeners, that's a deal where prosecutors agree not to file certain charges if the defendant meets specific conditions. In this case, Epstein pleaded guilty to 2 state charges, procuring a minor for prostitution and felony solicitation.
Okay.
He got 18 months in jail, though he served less than 13 with work release privileges. He did have to register as a sex offender, finally, and pay restitution to some victims.
But the huge part, the really controversial part, was what didn't happen.
Correct. Federal charges were not filed. And crucially, there was this sweeping clause added to the NPA. It protected any potential co-conspirators of Epstein from federal prosecution in that district in Florida. Any potential co-conspirators.
Yep.
And that was put in because the defense insisted on it.
The sources say it was included at the insistence of the defense team.
Yeah.
It's a really stark example of how that agreement was used to shield not just Epstein from federal charges, but potentially others, too.
And how were the victims treated during this? They were supposed to be consulted.
Well, this is where it gets deeply troubling from an institutional standpoint. The Department of Justice's own Office of Professional Responsibility later found that prosecutors deliberately concealed the NPA's existence and misled the victims.
Deliberately concealed it. How?
They told victims things like, "Be patient, the investigation is ongoing." Prosecutor Villafana admitted she avoided actually using the term NPA with victims.
Why?
Her reasoning was, most people don't understand what that means. Instead, she sort of hinted that maybe Epstein wouldn't comply with the deal and things may have to go to trial. It implied the process was still open when, in fact, the deal was done.
So the victims were completely in the dark about this agreement that directly impacted them.
Utterly. Courtney Wild, who became a very important voice later, she stated clearly in a legal declaration, "I was not told about any NPA."
And what was their reaction when they did find out? I remember reading about their priorities.
Right. There's an email from Villafana herself noting one victim was very upset about the 18-month deal she had read about in the paper. And this victim said she'd rather get no money and see Epstein spend significant time in jail.
Wow. That really speaks volumes. Justice over settlement money.
Absolutely. It showed their primary goal wasn't financial compensation, it was accountability. True justice.
So when they found out after the fact, what could they even do?
They fought back legally, they filed an emergency petition, they argued that the federal prosecutors had violated the Crime Victims' Rights Act, the CVRA.
Okay, what does the CVRA guarantee?
It guarantees victims certain rights, including the right to be informed about plea agreements and the right to be heard at sentencing.
So their lawsuit wasn't just against Epstein, it was against the government.
Precisely. It was a major legal challenge aimed directly at the federal prosecutors for failing to uphold the victims' statutory rights. A huge step.
Okay, so that battle over the NPA is raging. Then another major development. Virginia Roberts Giuffre steps forward.
Yes. Around 2008, we start seeing anonymous civil lawsuits filed against Epstein, seeking huge sums, like $50 million. Now, many of those initial suits got dismissed, but Epstein did quietly settle with quite a few alleged victims out of court.
And Virginia Giuffre emerges from that group.
She does. She was initially identified as Jane Doe #3 in some court filings, but she became a very public, very prominent accuser. And her testimony was incredibly detailed and damning. She stated Ghislaine Maxwell recruited her when she was just 16, working as a spa attendant at Mar-a-Lago.
At Mar-a-Lago.
Yes. Giuffre said the training started immediately. A lot of this training came from Ghislaine herself. And interestingly, her father, Sky Roberts, actually backed this up. He said he referred her for the job and used to drive her there.
So Maxwell was the recruiter, according to Giuffre. What else did she allege about Maxwell's role?
Giuffre was very clear. Maxwell's main job for Epstein was to find other girls that would perform massages for him and herself.
For him and herself.
That's what Giuffre testified. She even described Maxwell implying sexually that having other girls available sort of took the pressure off Maxwell because, as Maxwell supposedly said, she doesn't have the time or desire to please him as much as he needs.
Good grief.
And Giuffre clarified that not finishing the job, in Maxwell's terms, meant not bringing Epstein to orgasm. It made it crystal clear what these massages really entailed.
So direct participation in the abuse, not just recruitment.
According to Giuffre, yes. She alleged Maxwell regularly participated in Epstein's exploitation of minors, including Giuffre herself. And perhaps even more disturbingly, Giuffre claimed Maxwell took numerous sexually explicit pictures of underage girls. Child pornography, essentially, which she said were shared with Epstein. Some reports suggest the government actually has some of these photos.
It's incredibly disturbing. Did Giuffre's allegations stop with Epstein and Maxwell?
No. She claimed Maxwell directed her to give massages to other powerful men. She specifically named Prince Andrew and Bill Richardson.
Right. Those names became central later on.
And she went further, alleging Epstein sexually trafficked her, made her available to these politically connected and financially powerful people.
Why? What was the alleged motive beyond just sexual gratification?
Giuffre claimed it was strategic, to gain business, personal, political, and financial gain, and perhaps most chillingly, to gather potential blackmail information on these powerful individuals.
Blackmail. That's a recurring theme, or at least allegation, in this whole saga.
It is. And navigating these complex civil cases required skilled legal teams. Attorneys like Sigrid McCauley, Brad Edwards, Paul Cassell, they were really instrumental. Brad Edwards especially was noted for his expertise in civil trials. Their work was crucial.
So Giuffre makes these explosive allegations. How did Maxwell respond? This led to more legal battles, right? The defamation suit.
Exactly. Giuffre sued Maxwell for defamation, basically saying Maxwell lied when she publicly called Giuffre a liar. Maxwell's defense fired back hard. They argued Giuffre's story was completely made up, pure fiction. They even claimed no other witness has claimed, as plaintiff does, that Ghislaine Maxwell sexually abused them, sexually trafficked them, or that she partook in daily sex with any underage girls. They tried to isolate Giuffre.
And what was Maxwell's stance during her own deposition? Did she cooperate?
Not really. Throughout her deposition, she stuck to denials. Denied direct involvement, denied non-consensual acts, denied recruiting minors. She often refused to answer questions about adult consent sex acts, calling them irrelevant, denied knowing about underage girls, denied helping with visas, just blanket denials or refusals.
But then, objective evidence started to chip away at that, didn't it? The flight logs.
That was a major crap in her defense. The sources, court documents, eventually unsealed, included flight manifests. These showed Maxwell was on Epstein's private planes more than 300 times.
300.
Yeah, with very frequent trips noted to and from West Palm Beach, the epicenter of much of the abuse.
And how did that square with her testimony?
It directly contradicted it. She had testified under oath she'd only been to West Palm Beach maybe once in 2005. This kind of objective data became incredibly important in undermining her credibility.
And wasn't there another key witness who supported Giuffre's account?
Yes, Johanna Sjoberg. Her testimony was really significant. She also said Maxwell recruited her for Epstein, and crucially, Sjoberg's account lined up with Giuffre's on specific points, including being trafficked to Prince Andrew. Sjoberg described how Maxwell pitched the work as this excellent job opportunity, paying, $100 to $200 an hour. But she said it became clear very quickly what was really expected.
So corroboration started to build. What about the legal tactics being used in these civil suits?
It was intense. Maxwell's lawyers were constantly trying to limit depositions, control the flow of information. But Giuffre's team used specific federal rules of evidence very strategically. Rules 404B and 415. These are important in sex abuse cases because they allow evidence of a defendant's other similar acts. The idea is that these types of crimes often show a pattern, a propensity.
So they could bring in evidence beyond just Giuffre's specific claims against Maxwell.
Potentially, yes. To show a pattern of behavior. Maxwell herself even tried to dictate her own deposition schedule, naming witnesses without court approval. It was a real legal chess match.
Were they able to get testimony from others in Epstein's inner circle? People like Sarah Kellen?
They tried. But Sarah Kellen and another associate, Nadia Marcinkova, when they were subpoenaed, they both asserted their Fifth Amendment rights against self-incrimination. They refused to testify.
Pleading the Fifth. So key potential witnesses remain silent.
Yes. Which raises questions, of course, about what information remained hidden, what parts of the network stayed protected at that time.
And amidst all this legal stonewalling, the media played a role too. You mentioned the Miami Herald.
Absolutely crucial role. The Miami Herald in particular fought persistently to get judicial documents unsealed. They argued successfully that the public has a right to access these records, to observe and monitor the workings of the federal judiciary. Transparency was their goal.
And that push for transparency worked.
It did. It brought a huge amount of previously hidden information into the light details from Maxwell's travel logs, excerpts from victim testimonies. It fueled public understanding and outrage.
And Virginia Giuffre herself wasn't just passively letting her lawyers handle it, was she?
Not at all. Her determination was remarkable. The sources show she was actively seeking evidence herself. She even emailed the FBI directly, asking for copies of photos, videos, flight logs that they had confiscated, saying she needed them for evidential purposes in her case.
Just relentlessly pursuing justice on her own behalf.
Absolutely.
And she took her advocacy public, too, beyond the courtroom.
She did. She founded a nonprofit called Victims Refuse Silence. The goal was to fight sex slavery, yes, but also to help other survivors deal with the shame and intimidation that so often silences victims. She did public interviews, used her platform. It was about more than just her own case.
So this combination of legal action, investigative journalism, and public advocacy really started building pressure.
Immense pressure. Politicians got involved too. Florida Attorney General Pam Bondi released a first phase of declassified files, flight logs, contact books.
Those infamous flight logs and contact books, though heavily redacted, right?
Oh, yes, extensive redactions. But still, seeing some of those names associated with Epstein caused a stir. Members of Congress started calling for intense scrutiny of any attempts to suppress information or shield powerful people.
Okay, so we have all this mounting pressure, legal wins, public exposure.
Yeah.
But then there was that official DOJ memo in 2025. That seemed to push back again.
Right. That memo stated, officially, no incriminating client list, no actual evidence of blackmail, and therefore no basis to investigate uncharged third parties. It felt like an attack to shut down further inquiry into the network.
But despite that memo, the actions of the women had already set things in motion.
Undeniably. The direct legal actions, the civil suits, the settlements Epstein made, the public exposure, it all culminated. Ultimately, Ghislaine Maxwell was arrested, tried, and convicted in December 2021 for her role in helping Epstein abuse girls.
The conviction.
That conviction, along with Epstein's many settlements before his death, it really stands as proof. Proof that the voices of these women, even after being dismissed, facing huge legal hurdles, battling institutional resistance for years, they forced accountability. Maybe not perfectly, maybe not completely, but they forced a measure of accountability onto a system that had protected the powerful for far too long.
So when we step back and look at all this, what's the big takeaway? It
Yep.
feels like, well, a really hard-fought, painful journey towards some semblance of justice.
It absolutely is. The whole Epstein and Maxwell saga, especially as this part focusing on the women, it's just a stark reminder of the incredible obstacles victims face. It highlights systemic failures, definitely, but also the sheer personal cost, the trauma, the fight involved in speaking out against power like that.
Yeah, the personal cost is immense.
But on the other hand, connecting it to the bigger picture, it's also this profound testament to the power of one voice. And then what happens when a one voice becomes many voices, how they can challenge these really deeply embedded structures of power and secrecy. I mean, it took decades, literal decades, for the full scope of these crimes to even start being acknowledged. And that acknowledgement only happened because of relentless, dogged pursuit of justice by the women who were directly harmed. Their courage really did forge a path.
It really did. Which leads us and you, the listener, with a pretty heavy question, I think. When you have a system that seems almost designed to protect the powerful, what does it actually take? What does it take for individuals, persistent individuals, to break through that wall of secrecy and power and finally bring these seemingly untouchable figures to justice?